My name's Fadan. I'm a family law solicitor practicing in Sydney, Australia, and today I'm going to talk to you about a case involving family violence. This is a trigger warning. Some people may find the contents of this case disturbing. Now, the decision is called Dajani. It involved a property settlement decision between a husband and a wife, but let's get into it. Now, we have Cindy. Cindy is age 62. She's looking fabulous for her age. We have Harvey. Harvey is aged 65 at the date of the trial. He's looking a little worse for wear, with no head and no feet. That's just me. He obviously did have hair and feet. They were both retired at the date of the trial. They were together for 36 years, so a very long marriage, and they had 2 children who were both adults at the time of the trial. They had a son and a daughter. The daughter, Charlie, will come into this story. Now, the parties married in 1983. They separated in 2019 and divorced in 2021. In 2019, when they separated, it's also the time when the wife discovered about what the husband had been doing to their daughter, young Charlie. Now, in 2019, the husband was arrested. He was incarcerated. He was charged with offences, multiple offences involving SA of their daughter. He'd been doing it since she was a child, since she was 6 up until she was an adult. He pled not guilty at the trial in the district court. He was found guilty after the trial and sentenced to 17 years. He would be released at its earliest in 2031. The actual case was a property settlement case between the husband and the wife. Let me tell you what the court said. After a criminal trial, he was found guilty in relation to all charges, received an aggregated sentence of 17 years, non-parole period of 12, earliest release date 2031. Now, he filed a notice of intention to appeal on that date, but he hadn't actually lodged any appeal. So this was a property settlement case. The reason it came to court was they were dividing their assets now that they'd split up. Now, he was, of course, in jail, so he was running his case with his lawyers who had to get instructions from him from jail. Now, Cindy said she should get 70% of the assets, and Harvey said that he should get 60% of their assets. The entire pool was around $9 million, just short of $9 million, with a house worth $4 million and some superannuation worth about $3 million in other bits and pieces. Now, after such a long marriage of 36 years, why did Cindy think that she would get 70%? Why did she argue for 70%? Well, she relied on a case called Kennan. Let me show you what that means. Okay, this is the decision of Kennan. It's an old decision of 1997, and this is a nice little summary of what the principle means. It's where there was a course of violent conduct by one party towards the other during the marriage, which is demonstrated to have had a significant adverse impact upon that party's contributions to the marriage. So Cindy was saying Harvey's conduct during the marriage meant it affected her in an adverse way, and that she should get an adjustment because of it, because the contributions she did make were made significantly more arduous than they ought to have been. Now, many a lawyer has tried to argue Kennan, including me. It's a very, very small band of cases to which this principle applied. It is essential to bear in mind the relatively narrow band of cases to which these considerations apply. Now, the new laws that are coming in June are going to change that because it's going to put it in the legislation. Like family violence is in the legislation, it is defined in the Act. But it's not a consideration that is taken into account when we determine what you get in a property settlement under Section 79 of the Family Law Act. It's now going to be put into Section 79. It's not there at the moment. Lawyers would rely on the Kennan principle when we try to argue that as a result of family violence, our client should get an adjustment. That is, she or he should get more out of the matrimonial asset pool. Now, of course, the wife argued in this case that she wasn't aware of the SA conduct that was happening to their daughter, Charlie, during their relationship. She didn't have any idea until afterwards, until 2019 and onwards. So the husband said, well, how were your contributions made more arduous when you didn't even know about it? That's what your case is. He denied anything happened, but then he sort of threw it back at her and said, well, I don't understand. How could you say that Kennan applies to you? Because remember, it was the daughter who was being SA'd, not the wife. Now, the wife had lots of medical evidence as part of the case, including her psychologist, who said she diagnosed the wife with complex PTSD in the context of the prolonged coercive control she experienced at the hands of the husband, including verbal abuse, his behaviour, social and financial control, and basically what she went through at the hands of him. Now, it wasn't the same extent to what the daughter went through, but the daughter was very troubled. She was a very troubled girl. And because of that, the wife was the one taking to her to all her appointments and trying to address the behavioural issues and the issues that the child was having at school. And the wife was the one who was doing it, right? The husband wasn't. He was out going to work every day. Now, interestingly, the wife didn't call the daughter, because she was an adult by the time of the trial. She didn't call her as a witness in her case. She called her son, but she didn't call her daughter. And it was because she didn't want her to have to face her dad in court and be re-traumatised all over again after she'd gone through the criminal trial and got the conviction. She didn't want to put her daughter through that, so she didn't call her as a witness. So because the daughter couldn't give first-hand evidence of what happened to her, the wife couldn't give the evidence because that's hearsay. The husband then, as part of the family law case, tried to draw an inference. The inference is under a case called Jones and Dunkell, which means if you don't call a witness that was going to help you in the case, the court can draw an adverse inference that that witness wouldn't have helped you in your case, which is why you didn't call them. Now, the wife said, that's complete nonsense. I didn't call her for other reasons. And the court agreed. The court rejects any contention that somehow the evidence of Ms. C, that's Charlie, the daughter, would have been reasonably expected on the facts of this case. The husband's own daughter was also the victim upon whom he perpetrated sexual, for which he was charged, convicted and sentenced. Giving evidence would have been potentially re-traumatising, even if, as suggested by counsel for the husband, it had been given remotely. So they tried to use this inference, but it didn't work. Remember, the husband admitted some of the family violence. You can read that. You can see he conceded that he'd punched a hole in the wall, he'd lost his temper, hitting his fist on the table, he threatened to commit suicide on multiple occasions, he admitted he put security cameras in the lounge room and that he had a light bulb on his shed door activated by a sensor. The son gave evidence and said that he always felt like he was being watched. The husband agreed that the daughter was abusing the wife in the teenage years. Now, the wife also made submissions about the post-separation contributions that she made after she discovered what he was doing in 2019 and having to support the children through the criminal trial. So the wife was successful in her argument and she did get a canon adjustment. In the end, the judge gave her 62.5% and the husband 37.5%. She got 5.6 million and he got 3.36 million. Husband didn't like that. He thought Justice Altobelli, who made that decision, got it wrong, and so he appealed to the full court. It came before the full court, who's represented by Captain America, and I'll show you what they said. The husband's main ground of appeal was that Justice Altobelli had allowed the sentencing remarks into evidence. That is, the remarks that were made by the trial judge of the district court, the criminal proceedings, were allowed into the family law proceedings. And that was how the evidence was known as to what he had done to the daughter. Because remember, the mother couldn't give that evidence. Now, he objected to that and said, you can't use that. That was unfair to me and it was misleading and prejudicial. Now, the full court said that evidence was admitted not to show the truth of the events, but that it was fact that he went to trial, he was found guilty of all those charges, and these were the things that he was found guilty of. So it was proof that he was charged, found guilty and incarcerated. It's not truth that those things happened, it's truth that he was convicted of those things, if that makes sense. The husband tried to argue that the wife didn't know what was happening during the relationship, so she said. So how could her contributions have been made more arduous? And this is what the full court said about that. The reality is she was caring for Charlie. She was caring for her because that's what she was going through. It didn't matter who was doing it to her. The reality was she had to make those contributions to help their daughter, regardless of who the perpetrator was. Now, the judge found that there was a causal link between the husband's behaviour and the wife's pain and the abuse that she suffered. It's in this paragraph. The fact the wife wasn't aware of the abuse, the judge said, was completely irrelevant in the circumstances. The reality was she did make those contributions, which were relevant, and gave her an adjustment. The court said, all your grounds are shit, sir. So you know what? Go back to jail. You don't get to appeal. You don't get anything else. The appeal has been wholly unsuccessful. Fuck off. You lose. And you know what? Pay your wife's costs in the sum of $10,350. Here you go, puppy. You can eat him some more.